Should employers who already have arbitration agreements have employees sign new agreements? In light of the new Adolph decision, employers should assess their employment with their employment counsel whether the employees' arbitration agreements need to be updated. And if you do not have an arbitration, you really should evaluate with employment counsel whether Adolph provides a strategic and good reason for you to implement a new agreement now. So some of the factors that you want to consider: does your existing arbitration agreement have an invalid PAGA waiver? Does the agreement have an enforceable severability provision? The benefits of an employee re-signing an updated arbitration agreement is that all your agreements company-wide will have the same consistent language that is updated with the current law. And, originally you might have some employees who fell through the cracks and they never signed an arbitration agreement or never received it at the onboarding. This would be a good time to those people who fell through the cracks to have them sign an agreement, and be mindful that rolling out this new agreement may raise some red flags to your workforce. So be ready to answer questions about the agreement, have a strategy already in place to address that. And of course, if you've got a pending PAGA case, you need to confer with your counsel first before you do anything else. Now, $1 million question after Adolph: is it really worth it to have an arbitration agreement? Why bother? Well, the answer really is going to be specific to each company. Arbitration agreements aren't necessarily always right for everybody, but companies should review the issue with counsel. But overall, there are substantial benefits to using an arbitration agreement, even after Adolph. First, class action waivers remain enforceable, and they are essential to defending against costly and protracted class action litigation. Oftentimes, the costs to arbitrate will be less than the costs in court. There are a lot of factors that go into that. There's streamlined discovery, less depositions. I believe arbitrations are typically faster than court cases. There's few continuances in arbitrations, where in court there's a backlog on getting hearing dates and frequent continuances. There's also less time that's needed to prepare documents for the arbitrator. There's fewer formalities that are required in court, but not our arbitration. And the time that it takes to conduct the arbitration trial is going to be shorter than in court. Also, a key issue is with arbitration, you've got a waiver of jury fee. That means less costs, shorter trial time, and avoidance of verdicts that might be based on emotion rather than the evidence. And also what comes up a lot is that in arbitration, you're going to have more confidentiality, where a court proceeding is open to the public, including all the records, and the public can come in, watch all proceedings. That doesn't happen in an arbitration. And an arbitration agreement may, in fact, impact a plaintiff's counsel decision whether to take the case or not. So what are some of the disadvantages of arbitration? Arbitration agreements are often challenged by employees. That results in increased costs and uncertainty. Changes in the law require regular review of arbitration agreements, and we recommend that you have your arbitrations reviewed by experienced counsel on an annual basis. Significantly, the employer is responsible for paying a lot of extra costs in the arbitration, and particularly the arbitrator's time. A 3 to 5 day arbitration hearing alone could range in $30,000 to $45,000. Employees are also responsible for any additional time for the arbitrator at hearings, reviewing records, drafting orders, things like that. There's also limited judicial review, and the potential for mass arbitrations where you have more than a single arbitration at a time. So should employers have a PAGA waiver in their agreements? First off, you should review the existing agreement for any invalid PAGA waivers and immediately delete provisions or language that is inconsistent with Adolph. My recommendation is continue to use and enforce PAGA waivers in arbitration agreements, but modify the language so it's clear that any waiver will apply to the extent that it is permitted by law. That way, it covers you in the event that there's another change in this area of the law that impacts PAGA waivers. It's also another good reason why you should have those annual reviews of your agreements. I also highly recommend adding language that the employee's non-individual PAGA claim will remain stayed in court until the arbitration is complete. Lastly, it's really important to review your severability clause in an arbitration and modify it as needed. So the severability clause basically gives the judge the flexibility of striking out and disregarding language or provisions that are invalid. I recently had a case where the judge did exactly that. He actually ruled that two of the provisions were unconscionable, but he continued to enforce the arbitration because of a good severability provision.